Good morning. This is Boris Kozolchyk, and I'm very happy to have you in this webinar. Before I do some housekeeping issues, I've been informed by ASIL, by the American Society of International Law, that those of you who have questions, please contact events@asil.org. And also, you'll see at the end of the presentation a reference to where you could find or acquire the book that is a basis for much of this presentation upon your request. A number of you have requested that information, so it will be provided to you at the end of the webinar. This webinar is designed to reflect the experience of approximately 35 or 40 years of my own work and that of the National Law Center, before there was a National Law Center, on using commercial law as a tool for economic development. And the way in which it is going to be done is that I'll be making this introduction now in camera or in your view. Then we'll switch to the slides portion, which will be the majority of the presentation, and then the last 30 minutes or so I'll be back on the screen again, and then I'll be discussing or answering the questions that you would be interested in directing to me. So without more, I go now to the slides. This presentation will be divided in various sections. The first one will deal with commerce as one of the most cooperative activities, and why it is that its inherent cooperation in commerce requires a special approach to understanding how to draft the rules based upon principles that underlie the participation in commerce. How to understand how practices are collected, compiled, and serve as the basis either for usages and customs that have binding effect as the law, or as the basis for codification, statutory creation, judicial interpretation, etc. So it will be divided into the standard and best practices in commercial law and practice, first in Rome, then in medieval commercial law and practice, in European codification, United States commercial law. Finally, the experience of NatLaw in the drafting and implementation of statutes and compilation of usages and customs throughout the developing world, at this point in approximately 20 nations or so, starting out in Latin America and then in Africa and in Asia. Please bear in mind throughout this presentation that one of the central ideas is that at the present time, the notion of codification is illusory. Things are happening too fast in a very anarchic way in the commercial world, as new customs, new usages of trade emerge each day, and it usually takes no more than a decade to have to change them. In light of that experience, and in light of the need to have commercial law as a real tool for economic development, the following discussion will be focusing on, as I just described, the standard and best practices, their components, and how the role of the lawyer is central to that whole process as a guardian of the good faith of these practices and of the law that they create. Thank you. So what is a sociobiological foundation of the conclusion that commerce is essentially a cooperative function and one that is inherent to the nature of man? The work of the great sociobiologist, the founder of that discipline, E.O. Wilson of the Harvard University, and one of the world's most recognized biologists, indicates that man shares with wasps, bees, ants, and other animals in what he called the social creation, the socialization of the world. The particular feature that they're all cooperative beings. Those animals that have lived the longest, populated the most, as well as Homo sapiens, have that particular feature in common. And then in terms of the evolutionary process that the socioevolutionists have been examining for the last 2 or 3 decades, there's pretty much of a uniform conclusion that there are two processes. One which is of individual selection, which is a competition for survival and reproduction between members of the same group. This type of competition is usually one that encourages selfishness and usually doesn't last longer than the life of the member of the species, the individuals that compete in such a fashion. The other type of evolution is that of the group. Group selection is the competition between societies as organized groups, and it encourages the altruism of the members of that group, much as the individual selection encouraged the selfishness. This type of cooperation is indicated by these loving animals as part of a group, and as will be indicated by the bankers that participated in the revision of the UCP, or the original bankers that created the letter of credit and had it replaced. Other practices are characterized by the altruism of the members of that group. The principal legal tools of the commercial cooperation are not so much the rules themselves, because those rules are usually the ones that are created by the practitioners, especially by the regular practitioners in each trade. They are the ones that tell you how they buy, how they sell, how they lend, how they exchange goods and services, how they invest. What the lawyers and the law really contribute to that compilation of customs, of usages of trade, is, in our opinion, and borne out by the work of the center, the good faith, including the prevention of abuses of rights, both individually and as a group. The good faith that includes, as we'll see, not only honesty, or as it's referred to in some codes as honesty in fact, it also includes reasonableness, which is a behavior in accordance to the practices of a highly respected, decent, honest practitioner, the archetypal merchant. The third component of this degree of cooperation required by commercial law to truly become a tool for development is fair dealing, which imports the equal treatment of the equals in their trades, and a fair dealing also towards unequals, which requires a higher degree of good faith, one referred to by Justice Cardozo famously as uberrima fides, about which more later. The cooperative nature of commerce then revolves around these two principles of cooperation: reasonable selfishness and reasonable altruism. Now, an illustration of the interaction between reasonable selfishness and reasonable altruism that involves the letter of credit community and the revision of the usages and customs for letters of credit known as the UCP. In this case, what happened during UCP 500, in which I was one of the participants in that particular creation of a new set of usages and eventually a new set of rules, some statutory. So you have the issuing bank, who is the one that issues the letter of credit, usually to somebody in another country. That letter of credit is usually confirmed after being notified to the beneficiary, who's the seller, by a bank known as the confirming bank. And there is another bank that intervenes in that process as well, particularly when the letter of credit is a time letter of credit, one not payable at sight, on the presentation of documents, but payable, say, 60 or 90 days after such presentation by the beneficiary takes place. And this is the case of the negotiating banker, somebody who's willing to look at the documents and see whether they comply, and then, as you will see from the competing practices, either use the money of his corresponding bank, which is a confirming bank or the issuing bank. He has usually an account, a line of credit account with him that he could debit, or not pay at all until the confirming bank or the issuing bank tells him to do so and authorizes him to do the debiting of that account. In that type of circumstance, then it is very imperative that the question be answered, then what is truly a negotiation and what is a proper commission, a fair commission to charge for that particular function. During the revision of the UCP, there were two customs and usages that were very troublesome at that time. One was the abuse of the doctrine of strict compliance among correspondent banks. Strict compliance, as decided by an English court at the turn of the century, the 20th century, meant that only that compliance in which the documents, exactly as they were described in the letter of credit, were presented without any deviation, is the one acceptable. And the abuse was that the letter of credit, for example, called for the payment of 100 lots of hydrogenated water. Instead of describing the water as hydrogenated, there was a description which says H2O2, and that in fact was the same thing, but it was not literally the same description. So banks that feared not being reimbursed for some reason rejected such a presentation. That was one, and that was very common, particularly when the reimbursement by their customer, that is to say by the person importing the goods, or by another bank, was in peril. The second practice is that of charging excessive commissions for their negotiation, and not very clear as to what those commissions required by way of a giving of something or the performance of a certain service by the negotiating bank. So there were two archetypes, that is to say, two model practices that I discovered when I was questioning, surveying the practices around the letter of credit world. In the first one, this negotiating bank examined whether the documents were compliant, and then if it was a letter of credit for $1 million, after he examined that, he would charge $15,000 for the determination of compliance. Then, if he found the documents to comply, he would forward the documents to the confirming bank or to the issuing bank for their approval of payment. If the CB approved, then the NB would debit the line of credit that it had with his correspondent. If the other one rejected the presentation, he would notify it to his customer and then pass on the customer's message, but basically withdraw from the transaction, having kept his $15,000 for the negotiation. In the second negotiation archetype, this was one which was first responded to not by a negotiating bank, but by a confirming bank, whom I asked the question, put yourself in the shoes of a negotiating bank, and what would you do as a negotiator, and what would you charge for it? The response was, I would examine the documents with reasonable care, and if these documents complied, I would negotiate with recourse on the buyer. And that meant that his examination with payment was final. That is to say, he assumed responsibility for having made a mistake in determining that the documents were in compliance, and that when in fact they were not. If his examination was mistaken, he would reverse his debit to the CB's account, and then would not charge a commission for 2B1. The proverbial reference that this banker made to this practice was one in which he would have, quote, to eat the documents as a result of his mistake. So what did the, let's call him the archetypal banker who acted as a negotiating bank, having been the confirming bank in the transaction? what would that person criticize the first practice for. And the criticism was that the negotiating bank that charged without actually assuming responsibility for what he was doing would be practically acting not as a bank but as a post office, forwarding documents back and forth, and for that charging a very significant negotiation. And then when I asked this particular confirming bank, what was it acting now as a negotiating bank? What was it that he would do as a negotiating bank? His reply was, whatever I charge for negotiation, I must give value to the payee, the beneficiary, and I was refrained from taking advantage of the trust placed upon me by my correspondents. When I circulated these two versions of what negotiation was and how many people, bankers around the world, agreed to one or the other version, the vast majority, when asked to put themselves in the position of the negotiating bank, as I asked this particular archetype, said exactly the same thing. And what he said was, whatever I charge, again, must give value to the beneficiary, refrain from taking advantage of my correspondence. This is what led to the rule that appears in Article 10 of UCP 500, and which is characterized as the best practice. It reads as follows. Negotiation means the giving of value for drafts and other documents by the bank authorized to negotiate. Mere examination of the documents without giving of value does not constitute a negotiation. Now, this led to the characterization of practices as those that are standard, that is to say, those that are practiced by the regular participants in the transaction every day, and which, as you noted from my use of a negotiating bank as a confirming bank and vice versa, these are interchangeable because the banks change roles. It's a practice, it's a sector, it's a business in which today's issuer or issuing bank is tomorrow's negotiator, today's confirming bank is tomorrow's paying bank, etc. So they change their roles. So their practices have to reflect the fact that they must constantly place themselves in the position of the other, because they could be the other coetaneously or 5 seconds later, etc., in another transaction. And that is what amounts for the, call it the good faith, the honesty, the reasonableness, and the fairness of that particular practice. The test is, how would that person act in the position, not necessarily of the individual person with all his traits, but an archetypal banker, somebody that is highly respected by the other bankers when doing the same functions. The other practice, which is one that I refer to as the best practice, is one that takes into consideration not only those interchangeable roles of the regular practitioners, but takes into consideration the problems faced by a third party. Who is a third party? A party could be a third party, it could be the customer, either the buyer of the goods or the beneficiary, or it could be someone else that for some reason in the transaction entrusted the banks to act as their advisors and to basically, in a fiduciary capacity, handle their money. Those practices would require a higher degree of good faith, the one that I've just mentioned referring to Cardozo's notion of an uberrima fides, that is to say, you have to treat these people as if they were your younger brothers, as once told me by one of the judges that also answered this question. Go ahead, please. So what would an honest, knowledgeable, and well-respected practitioner do as a regular practitioner? Basically, as I've just described, because of the interchangeability of these functions, you have to identify who that practitioner would be. I propose the adoption of a manual that compiled the standard and best practices of a banker that I refer to as a reasonable document checker. That is to say, somebody whose colleagues would respect for the knowledge, for the decency, for the honesty, the integrity, in the transaction, even though it might not coincide with a living actual banker. This is the concept that was adopted by UCP 500 in Article 13 when it talks about international standard practice. And when it says that the banks in Article 13 must examine all the documents stipulated in the credit with reasonable care to ascertain their compliance with the terms and conditions. Compliance of the stipulated copy shall be determined by the international standard practices as reflected in these articles. So this is the first adoption of the notion of a reasonable document checker, and you will find it also in very successful international treatises, such as, for example, the United Nations Convention on the Sale of Goods. When you look at Article 8.2 of that convention, it will tell you that interpretation of sales, international sales, should be done in accordance with what would be the interpretation of a regular participant in that trade, acting in that capacity. So it's a standard that is already present in some of our major international commercial law treaties. Now, how did these standards originated? Where do they come from, and what effect have they had? The first society and legal system that I looked at was that of Roman law. It's very important, as you'll see through this presentation, to try to identify some cultural features in that society that tell you the role that commerce plays. Depending upon how commerce is regarded in those societies, then the practices and the rules that emerge from them are going to be very different from another in which commerce is regarded and merchants are regarded differently. So the cultural factor behind the creation of these practices is very important. Now, according to Cato the Censor, Cato the Censor, the Romans admired the virtues of their farmers and if they're brave soldiers, and if they can combine them both, that's even better. But they were not particularly admiring of merchants whom they regarded as grasping and who lacked the dignity that they ascribed to the Roman legionnaires and to their farmers, many of whom became legionnaires, for one. The Roman jurists were the most famous lawyers, perhaps, of all time in terms of their contribution to the law, and particularly to private law, over the next centuries after the decay and fall of the Roman Empire. Their principal contribution was what I would call, actually following Rudolf von Jherin's famous reference, they were the creators of the Roman legal alphabet. That alphabet is taken from their observation of the practices and of the terms used by the Romans, buyers, sellers, lenders, exchangers, etc. So the Romans were the first ones to coin, the Roman jurists, terms for sales, for loans, for barters. And then they were also responsible for distinguishing between those institutions. By institutions, I mean principles, concepts, rules, transactions is a very comprehensive terms. Everything that lives within a legal system is a legal institution. Well, the Romans measured the distinctions between legal institutions by a form of logic that, for lack of a better term, I call geometric, which is one in which they ascribed sizes to sizes to the actual transactions. Thus, when one conveyed something fully as in a dominial or full absolute owner capacity, then that particular person had better rights, more powerful rights than someone who was just a tenant in that land, or somebody who was a life estate holder. And the same thing was true with the law of contracts. In this particular measurement, this by geometric logic, had sort of its maximum axiom in the expression that nobody can convey what does not have. This geometric logic enabled you to determine what that person did have. So what is the logic of the reasonable? The logic of the reasonable is one in which One very famous Roman jurist, one of my favorites, Ulpian, said about the sale of a slave. This is a sale of a slave in which the seller said, yes, I'll sell this slave to you, but I have to be satisfied with the accounts that this slave will render to me after we have agreed on the sale. So the question was that Ulpian asked is, what should be the measure of the quantity or the quality of that set of accounts that the slave has to render? Is it going to be solely the arbitrium, the discretion of the seller, or is it going to be somebody else? Because if it's just the seller, then a whole bunch of jurists who had said that that clause was unenforceable, it was an illusory obligation, as we would call it today. In turn, Ulpian said, it is not that discretion of that seller, it is the discretion of a bonus vir. Who's this bonus vir? This is an honest, decent merchant, an honest man of affair who others would go to, who knows the sale of slaves, who knows how people do it and all that, but also who has the integrity, the decency, the honesty to say, let's not give too much to the seller by way of rights and too little to the buyer. Let's make it a fair type of a deal. Go ahead. But the problem with the development of the institutions that we'll be discussing later, one of them will be, as you know, secure transactions in Roman law, and why Roman law did not, after starting out with a number of very good definitions of terms and concepts associated with secure transactions, never materialized that transaction in Rome. The Romans started out by telling you, for example, what is a secured loan, identifying what we'll refer to shortly as a nuclear practice, using collateral as a means for the repayment, allowing the collateral, in fact, to be transferred, allowing the collateral, in fact, to be retained in some cases by the debtor to repay the loan, allowing for after acquired collateral to be part of the security, on and on and on. Yet, why was it that secure transactions did not emerge fully formed out of Roman law as we know it today? Why was it that it took almost 2,000 years to have what we have today in the law of secure transactions? And the answer is very simple. Much as there was geometrically measured individual rights, and much as there was what E.O. Wilson referred to as individual selection, in fact, it was a society in which individual selection involving the have and the have-nots was the rule of the day. There were very few lenders, the aristocratic landowners, and the rest were just very poor people, including many slaves. So when it came to trying to find how to have a fair deal between the rights of Roman debtors and creditors and not allow the creditors anytime practically that they wished through the so-called pactum commissorium to retain or repossess the collateral of the debtor and make it his, etc., make it theirs. There was constant, if you look at the complaints to the Roman emperors found in the so-called rescripts, thousands of these complaints about these abusive practices. And eventually many of them degenerated in armed conflicts and even insurrections. So the conclusion is that the logic of the reasonable that should have been used in order to search for a fair dealing between Roman debtors and creditors and third parties, incidentally, notifying third parties of the existence of those transactions through registries or otherwise, which did not exist in Rome, that was not there. And as a result of that, even though there was the ability to measure rights and duties geometrically, there was no fair dealing between Roman debtors and creditors. And now, what happened in the Medieval Ages and what particular practices are very significant to the development of a commercial law that could contribute to economic development? For that, I turned to the medieval practices of Jewish traders in the Mediterranean. And that was possible because at the turn of the 20th century, there was a discovery in a Jewish cemetery in Cairo, Egypt, of the entire correspondence of the merchants involved in medieval trade in the Mediterranean area involving Egypt. Any document that contained the name of God, as you'll see shortly, had to be stored there. And by the storage, these people gave us a pretty good indication of how they did business. The answer was that informal trade, which competed and in effect displaced another practice, which was the practice of the caravans, a practice in which the merchant always had to accompany the goods and was a very distrustful practices. This turned out to be a very trusting practices. The development of this informal trade depended very much upon altruistic entrustment. An altruistic entrustment that was reasonable. So those rules of entrustment derived from a religion in which the participants in these practices were religious brethren, and they have brotherly duties towards each other. These are three of those duties, the ones that I'm now listing. Whenever a Jew lost property by accident or through thievery, another Jew found that property in the hands of another person and bought it from him. If he did not know that this property originally belonged to the other Jew, and the original Jewish owner appeared and recognized his goods, that purchaser had the right to have the goods returned by that other Jew who bought him and who could only recover or recoup his expenses. The other practice, there are three, but the other one is the one that involved co-adventurers as passengers in the same voyage. When one of them died or got very ill, it was the duty of the other one to, quote, pick up the bundle. That is to say, the goods being used for traffic or trade in the various countries, sell them, and then return the proceeds, including the profits, without charging anything for their services to the widow and orphans of the deceased merchant. Then what happened with this particular, perhaps we could go to the next slide and look at the nature of this entrustment in a letter, one of the many found. See what this letter says. My lord, I have instructed another, this is another traveling merchant, a brotherly merchant, to buy saffron for X thing and his sums he owes me, and to send everything to you. In case he's unable to buy the goods, he should send you the cash. And then if God ordains a safe arrival, then take from that 25 dinners, do it for this, then give it to your children who will be partners with my children, on and on and on. This was all the formality that was required for the entrustment of significant amounts of goods, not only among a group of traders, but their families as well. So if we look at the resulting institutions, what was it that came out of this particular type of trade? You will find that the repeated reference to in God's name was a manner of ensuring that if there is a lie and somebody by a judge or by a rabbi is required to take the oath, that oath would have the ominous consequences, that it would be perjurious of God himself or herself. And then under those circumstances, it was very seldom that a merchant would take that oath. So that was the normative skeleton of this type of practice, which was a practice of entrustment. There was a reasonable type of an entrustment in terms of the fact that there was something that it was in it for everybody. They all received benefits from it. It was full cooperation, and it could be enforced by the presence of the name of God that gave rise to that ominous oath that kept them in line. So the next period we'll be looking at is what was it during the medieval European fairs, and what were their main contributions to what I would call these basic principles of the commercial law and of its contribution to economic development. The medieval fairs were characterized by the development of standard practices among regular participants, usually for different trade. And the degree of detail of this practice could be seen in the fact that certain goods would be sold only on certain days, and the pricing mechanisms were already established, some by weight, others by measure. Then there was a practice of payment that was common to the regular participants in that trade, and that was that many times those payments would be paid not at that particular fair, but months later at another fair, which was known as a clearinghouse or netting fair, in which the regular participants would sit together with a third party, sort of in an accounting capacity, and verify that their respective debts reflected as credits and debits in their respective accounts or books were all correct. If there was a dispute, then there was a development of very informal courts, sometimes referred to as dusty feet, or courts of pied poudre, courts in which the feet of the merchants were dusted and would not likely stay there very much and collect more dust as they went to do business elsewhere. And that was based upon these practices that I've just described. And then there was an element of fairness that the Romans did not have, particularly when dealing with strangers. This element of fairness involved what was known as the peace of the marketplace, presently known as the national treatment. It required that a pre-existing practice in many fairs, that if somebody from another country or location owes a local participant in that fair any money, and somebody else from that original country comes to this fair, the local merchant could secure their imprisonment and many severe punishments until he or she paid for what was owed by another merchant that this one did not know or had any idea of who or she might be. So this way of treating the foreign merchants was eliminated by the peace of the marketplace and is the subject of what is called in free trade agreements today the national treatment. Treat the other contracting party from another country as it is one of yours. The emergence of these usages for the various trades obviously were the ones that gave rise to the law of merchant, which we know to this day. European codification. What did it do and not do? We have to split it into two parts. One is the Napoleonic type of codification. The other one is the Germanic type of codification. The Napoleonic codification was one in which the nature of that society, and particularly of the status of merchants, played a very significant role. The favorites in the Napoleonic view in that society, the favorite citizens, were the landholders, particularly the aristocratic landholders. They paid their taxes, with that supported the state and the Napoleonic armies. In contrast were particularly the retail merchants. These were usually regarded, as Cato had regarded them, as grasping in nature, highly unreliable, highly untrustworthy. What were the archetypal transactions of these two types? Of the landholders, it was the sale of land, the mortgage of land, relying on notaries public. The others, the retail merchants, in many cases was the sale not only of new goods or old new clothes, but old clothing as well. The credit was informal and mostly was on a cash basis. In that Napoleonic society, the prevailing notion of usury was any interest that you charge for a loan or for an installment sale is going to be a usurious loan, even less than 1%. And the bill of exchange, which was a payment instrument in which one party ordered another situated elsewhere to pay a certain amount of money, and which was labeled not only a bill of exchange, but a contract of exchange, that is to say, to be used in a foreign exchange, was very frequently used as a subterfuge to avoid being regarded as a usurious transaction because of incorporating interest for the loan of money. This presence, this overwhelming presence of usury as a possibility of an essential element of any commercial contract was reflected in the nature of the first European formal or official commercial courts, which a scholar has referred to as virtuous courts. There were virtues because these merchants, being afraid of being characterized, it was a court of merchants, and obviously being afraid of being characterized as usurious, they tried to portray themselves as very virtuous, religious human beings, attending mass 3 times a day, and always trying to do what was charitable, etc. So there was this famous case involving a prostitute that went to bed with a young aristocratic landlord, and then at the end of their sexual intercourse, he decided he was so enamored of her, happy with her, that he gave her a bill of exchange, which he signed with his own blood, only to change his mind when the payment came and trying to get out of it, claiming that it was usurious. This case came before this commercial court, and the commercial court, trying to do the Christian thing, decreed nothing about the usury itself or the transaction, but found that he had acted so badly that he had to marry the prostitute. Napoleon was very unhappy with that decision, obviously, but that will reflect to you the nature of that court. The notion of usury overwhelmed so much the nature of the transaction that in this case, something totally out of the purview of a commercial court, such as ordering a marriage, was found to be necessary to save the reputation of the judges. Then we go into the logic that was beginning to be used in the Middle Ages in order to write various compilations of customs and local statutes. This was the Aristotelian scholastic logic. This is a logic that relies on the permanent and universal essences of things. You have to identify a thing by what is its permanent universal essence. And once you've identified what is that permanent and universal essence, which is its unique feature, no other object could have it, then that stays forever and everywhere. That is to say, it's unchanging and it's universal. That's in the case of law, for example. You have to say, well, what is a contract? How would you define a contract? You have to find its genus, which was that of voluntary obligation, and then you identified the species of contract, and that is which voluntary as opposed to involuntary, such as coming from torts or from extra contractual liability, and there you have a permanent and universal definition, and with that you can define a contract forever and ever, and more importantly, what is a contractual obligation forever and ever. So the Code Civil, the 1804 Code Civil, unfortunately relies on these types of definitions and classifications, and many of them, such as involving what they regarded as policitations, become unenforceable. In our day and in commercial society, policitations are perhaps 90% of the transactions in the number of the actual number of transactions. Most of the stock exchange transactions, most of the commodity exchange transactions, most of the important real estate transactions import a liability of one party that promises to be bound for a certain period of time, and during that period of time that party cannot revoke that obligation. Well, that would be unenforceable up until very recently, incidentally. Up until a couple of decades ago, France could not enforce them, particularly in electronic promises. They had to undo that definition of contract because it required both parties' consent, and otherwise it was a totally revocable obligation. The effects on that and the interpretation of the civil code of this permanent and universal Aristotelian scholastic form of writing law is that the interpretation is always very literal, It doesn't take into account the goings on in the marketplace. The remedies are very puny. Principal and interest is the most you could usually get. Contracts are supposed to have an element of causa, which is an element of a contract that you could not determine before you enter into the contract, because very frequently, if during the performance of the contract something emerges that is unlawful, suddenly something that you entered into thinking that it was perfectly enforceable doesn't become so. It is undone. And then you have, as a result of all of that, for example, in the area of public finance in Europe in the 18th century, late 17th century, you had transactions such as the financing of public housing by the sale of mortgage debts, and other transactions that were used in Germany and in England are not usable in France and Spain, and consequently many parts of the development of those countries suffer: the financial sector, the construction sector, etc. Germany is a different story. The German merchants were not regarded as by Napoleon as when he criticized England as merely un pays de boutiquiers, a country of shopkeepers. German merchants, particularly in the 17th and 18th century, grow significantly. Their numbers grow as the guilds start dissolving. You have many more individual merchants. You have the verlegers, who are the ones that provide former guild members, including seamstresses, with money with which to buy the cloth, buy that dress or whatever from them and resell it or share profits with them. So this is one of the emerging factors of capitalism in Europe. So that was already visible in Germany. And then the financial marketplaces of Germany and England also emerge, while France and Spain are nowhere in that regard. Then in addition to German codes, you can inform the firm promises, including the French solicitation. You could enforce executory promises or promises payable in the future at a future time, which almost is crucial for credit. You could inform and enforce loans as long as their interest is non-exclusive, as a result of the redefinition of usury under Protestantism and Calvinism. Then it is a question of what is an excessive charge, rather than any amount charged for interest is usurious. And then you have non-clause bound obligations, such as abstract promises, such as mortgages and mortgage bonds. So the interpretation of German contracts also differs, particularly commercial contracts, differs to the usages of the trade, and rely on an archetypal merchant, a descendant of the Roma's bonus vir, the honest, decent merchant, that is found throughout German, not only statutory law, codified law, but also the courts refer to constantly. Your remedies, as witnessed in the remedy of Nachfrist, or notification to the debtor before you decide that you need to rescind the contract as an aggrieved party, is available under German law. You'll find it also in the International Convention for the Sale of Goods. Then we go to English law. In English law, you have the opposite of the Napoleonic approach to shopkeepers. It had a lot of shopkeepers, but they became much more important merchants. And in addition to that, by that 18th century, England was the hub of the industrialized world, and it was also the hub for the organized credit market, first in Europe, then throughout the world, until the end of the First World War, at that time in which the United States replaced England as the hub for international finance. The case law contribution in England was very significant, as significant as the law merchant had been. One particular case is very important in terms of the development of the enforcement of executory or promises that entailed the giving of credit. Slade's case. In this case, somebody had sold grains to somebody else and when the date of payment came, they failed to pay. That defendant was sued, Slade sued the seller, sued Humphrey on a new cause of action, well, a transformed cause of action known as a sumsit. The existing cause of action was just not one on debt, which means that you had to sue to recover something that you had given physically to the other party. In this case, it would have been the grain. There was no delivery of grain yet, and yet Humphrey could sue for the fact that the promise that had been made by the other party. And the reason the judgment relies on the presence of, quote, consideration. Consideration is the giving of something of value, including a promise, makes the promise to deliver, the fact that it was not delivered at the time of the delivery when it was due, make it enforceable. So with this in 1602, you have a rule that did not become the actual rule in France until 1804 with the enactment of the French Civil Code, which says that the parties, the contract is the law of the parties. In other words, they can agree to that type of a promise if they want to. This was not possible in many other countries around the world, but it was first done in England in 1602. And then you have a number of great decisions by one of the greatest commercial judges of all time, Lord Mansfield. Examples of it is Pilas versus Van Meyrup, in which a London banker had sent a bill of exchange to a Dutch banker and asked him to pay a client of the London banker there who had given money to the London banker to issue that bill of exchange. The Dutch banker did pay on that bill of exchange, and later on, when he tried to recover the monies from his correspondent bank in England, the correspondent bank came up with the defense that whatever he received from the London banker was, quote, past consideration, and the law of consideration requires that it be present consideration, that it for that particular transaction at that time. Mansfield looked at it and he replied saying that the writing among merchants, a writing is the one that takes the place of consideration, which is merely evidentiary in nature. If you have a writing among merchants, their writing is like their words, and their words is like their bonds. In other words, it goes back to the Roman definition of good faith, in which an acceptio doli, that is to say, one can accept the payment of an obligation based upon not only something that was actually thievery, but an abusive practice. In this case, an abusive practice, meaning an abuse of the doctrine of consideration, an interpretation that was hyper-technical, would not stand among the law of merchants because it's their words are like their bonds. The other two decisions, Miller v. Race establishes the connection between good faith, again defined both as honesty and non-abusive practices in the protection of the holder of negotiable instruments. And finally, to me, one of the least noticed, but most important of the statements ever made by Lord Mansfield concerning what are these essential elements that I was referring to in the cooperation in commercial cooperation. In another case, he says that when one sells for a sound price without giving a warranty for what he sold, may be a ground for an action on a sumsit. Basically, what it's telling you is that at the root of commerce, there is a need to reason, some need to give, like that banker said in the letter of credit revision in the UCP 500, you give something of value. And at that point, that is something that firms up the obligation. I should add at this point that this giving of value in England is very significant because England would never have become the credit society that it did become. It had not been by approaching debtors by their creditors who were fully awash with money as a result of the actual slave trade in the Caribbean with monies that they were basically offering to lend them. That fact that in a practice it started out by somebody saying to the other, I give you this, engenders a degree of trust, as proven by the anthropologists. When you give something of value, even gifts, and particularly gifts, a relationship of trust gets started, which is extremely important in the development of commercial law. We turn to the U.S. And its place. I'll skip a lot of what happened during the 19th century, but I'll turn to the UCC, to the fact that the Harter Act, enacted at the turn of the 20th century, already marked what was not present in the Roman law of secure transactions. The Harter Act, which replaced the attitude in the English law when Britannia ruled the waves, in which was an attitude that said that the carriers of other people's cargo were responsible for very little, whereas their shippers and their consignors were responsible for most of the duties in the contractual carriage. This was replaced in the Barter Act by making it a much more symmetrical statute of rights and duties. That marked lawmaking in the United States and marked a lot of what appeared later on in the UCC. In the UCC, particularly in Articles 2 and 9 on sales, 2 and 9 on secure transactions, you have a very marked attitude towards a symmetry of rights and duties. If you look at Article 2, for example, what are the rights of the sellers and buyers and their various causes of action? They're listed totally in a symmetrical factor. To one remedy for the buyer, there is another one for the seller, etc. That reflects that spirit, that the participants in the transaction, particularly the regular participants, have to rely on that element of cooperation that was present during the writing of the UCP among the bankers, and it's present among buyers and sellers in Article 2. Then Article 9 of the UCC is a very influential statute that, incidentally, Article 2 was an inspiration for the International Convention for the Sale of Goods. Article 9 has been very influential in the work of the National Law Center in developing nations, because it first became an inspiration for the OAS model law. Then it was adopted through the OAS, parts of it, very significant parts, in 8 countries in Latin America. And then, thanks to the work of our Dr. Marko Dubovic, this Article 9 also influenced the law and the law of countries in Africa, such as Nigeria, Ghana, Malawi, and then in Asia and the Philippines, then Kenya, Sierra Leone, Zambia, and others. So now the drafting and implementation of commercial laws in developing nations. What is the NatLaw methodology in our experience in doing so? First of all, if you look at the slide, you will find the fact that it is always very important that whoever is going to be participating in the process of drafting laws identify the nuclear transaction. Let's call it the nuclear cell. In the case of a secure transaction, it is the fact that you have to have somebody who is a secured lender is willing to lend money to a securing borrower using one or more assets of collateral. Then after you have that secured transactions cellular or nuclear practice identified, then you could see how others add to it, which should or should not be added, and which are consistent with the nature of what is part of this exchange, symmetrical exchange of rights and duties that must take place in the nuclear and subsequent cells. So in cell B, the practice was added was the fact that the debtor can remain in possession of the collateral and thereby be in a position to repay his loan best. It could coexist with the practice of retaining in possession or the practice of transferring the possession to the creditor. Then the notice practice, the importance to gain more marketplace for other lenders, the ability to let them know what is being borrowed by whom and what is the value of the collateral that they could assess in terms of whether there is any collateral left worth using in their own transactions, by people also who want to buy goods that are being used as collateral. All of that requires public notice. And then you establish as your principle and the public notice that the first to file is the one that is the first in right. Then the next type of practice that comes about is the use of something called a line of credit, which is the amount lent has to be in direct proportion with the value of the collateral. And then that gives rise to a practice of lending based upon a sequence of goods that starts out with, say, a merchant's inventory, the merchant's equipment, followed by the accounts and proceeds, and then that becomes the collateral itself, including future goods or rights that inure to that. And then comes the first question, which requires the determination of what to do. What about somebody showing up and saying to a given borrower, I'll give you something which is very exclusive to me and very valuable in this marketplace? It was an actual example. It was a question of pharmacists in Guatemala being told by the sellers of a very popular medicine for impotence, Viagra, that they would sell it, but based upon the fact that they would acquire a special priority. And that special priority would require that the filing of the security interest in Viagra, even though it was later than the filings on the filings on inventory, say, would take priority, because that provider of the Viagra would have priority in the sense that he would giving much more value than the others combined to the inventory, etc. So the geometric logic and the Aristotelian logic would say, no, you've already defined notice the way you have. That is permanent and universal. You cannot touch it. But the logic of the reasonable would see, well, how many people are benefited? Are the same people that have an earlier security interest more likely to be repaid sooner, more likely to use the same amount they lent in other loans and make more money? Once you inject the logic of the reasonable into that transaction, then new practices could be accepted or rejected, but they have to work together with the geometric logic and the precise definitions that have already been made. Then how do you do that? How do you actually determine what information you need in order to be able to write better laws, ones that really influence the economic development of that country? You need something which is highly factual and which uses the logic of the reasonable, and that is the roadmap. The roadmap examines, first of all, what are the essential practices that the previous slide gave you and what they got there, and use that as a reality check against the possible rules that you're going to come up with. Because the development of those practices would tell you which are the ones that are truly reasonable in terms of their selfishness, reasonable in terms of their altruism. Once you know what those practices are, you could start trying to find facts that will help you determine what is happening in the local markets. Who are the lenders? Who are the borrowers? What do they secure their loans with? What are the most knowledgeable and respected lenders and borrowers, and why? So in other words, you start identifying archetypal lenders, determining their reasonable practices and what is their justification for doing that. You must do the same with bad faith practices. You must identify who are the likely people and the practices that could derail what you're trying to do with these other reasonable, altruistic, and selfish practices. There were some examples. For example, when we were doing our first law in Latin America, which was in Guatemala, we inquired, the Guatemalans insisted very much in having both the judicial summary procedure coexistent with a repossession based upon and resale based upon voluntary practices stipulated in the security agreement. So the question was, how could one derail the other? So we talked to the lawyers that specialized in doing just that type of a derailing with regard to other types of priorities. And they all involved a so-called executive action and an interlocutory order by a judge that could be filed at any time and stop whatever procedure was going on. So we had to involve at that point the rule that said that whatever interlocutory order is procured by a debtor trying to prevent such a repossession or foreclosure has to be filed in time, that is to say, has to proceed in its filing, the filing of the pre-existing security interests. Then another critical element, fact, that must be taken into account in the writing of these laws is the role of familism. Curiously, the more work we did across the world, the more we found that there were elements in common in these developing nations, which were cultural components, but had a very direct impact upon the law. And the most important of them was familism, defined as normative preferences for those who are members of the same family, clan, or tribe, and its effect is a lack of protection for third parties. I would also add that its effect is a total distrust of strangers. When we started our work in Costa Rica, for example, we inquired why was it that people were not buying certain shares of stock that had a 10-year history of paying 8% dividend a year and were very profitable businesses, and instead preferred to buy mortgages that paid only 3.5%. The answer was very quick in coming. If that share of stock was such a good deal, why offer it to us? We're neither family of that company, we're not even their friends. They have no real interest in helping us. That's probably just puffery or probably a lie. Now, the effect of familism also is very, so that entails a distrust in that you're driven away by institutions such as stock markets, public listings of anything, because it's of strangers. The other effect is not only on the viability of, it's on the viability of secondary markets, which is what I'm just referring to, but also it's the type of familism that engenders uncertainty on valuable property that you buy. You have the same rule, incidentally, in countries like China. I didn't list there India, but India was the same type of thing with regard to what is called frivolous transactions or sales. Nigeria, in Costa Rica, in Guatemala, most in Mexico, and that is that if the party is somebody that you do not know, that the rights of that party are going to be much less certain than those that the ones that you know. We learned a lesson when we were in China, and I saw Confucius being cited everywhere. Confucius's temples where students went in order to try to get better grades, etc. I started reading his Analects, and I found one in which one of his disciples says to him, "Master, you talk about a superior man. I just think I met one. I think I just met one, and one is a son who found out that his father was stealing sheep from his neighbor and denounced him to the prefecture." To which Confucius replies, "In my kingdom, a father must always shelter his son, and the son must always shelter his father." Now, at the expense of whom? In this case, that sheltering meant that the third party who had suffered the thievery of his sheep was less protected in that Confucian view of the world than a family member. So family also implies the proliferation of monopolies, exclusive dealings, and the fact that if you're a regular participant in the marketplace and you do not know somebody with one you have, what the Chinese call the guanxi, for example, you're much less likely to be treated fairly in that transaction than if you were a guanxi member. Finally, the comparative legal analysis. The Once you've established all these facts, once you know what your practices are and you have that reality check that I was suggesting, you look at the various family codes. You'll find obviously that if you wind up in a country that follows, let's say, the French Civil Code, and you're talking about introducing factoring, which presently in Chile is about 15% of their GDP, you're told by a civil law professor that you could not do that because an account receivable is not pledgeable. Why? Because it is intangible, it's incorporeal. As the civil code says, there are only two security interests, that which is the mortgage, which is for real property, and the pledge for corporeal personal property. Well, there goes 15% of your GDP. The type of judiciary and administration, the doctrinal law, the legal education, how open is it to empirical or field research, such as in the roadmap? How open is it to the logic of the reasonable? The determination of these considerations facilitate the adjustment to the modernization of the laws and practices of all these countries. And it finally leads us to the question of the role of the attorneys as guardians of the good faith of the transactions. The good faith being defined very broadly, as it is defined in the German Civil Code, as it is defined in the UCC, i.e., fairness not only as honesty in fact and non-abusive of the rights of others, good faith as reasonableness, putting yourself in the position of a knowledgeable, respected archetypal merchant, and also fair dealing. If attorneys that are comparatively law trained, that is to say, trained in the type of analysis that you've heard here today, could participate in the drafting of these rules, of which the present marketplace requires that there be many more compilation of practices than you'll ever have of codes. If attorneys could participate in a process similar to the one that I described in the UCP 500, you will find that many of our financial crises, which lawyers could have avoided, would be avoided. You would also find that there will be a signal contribution to the economic development of both developing and developing countries alike. I finish with reminding you, those of you who called me and asked me to give them the citation to the book, that you could get it either from West Publishing Company as a horn book or from Amazon. And with that, I'm open to questions. Remember, if you haven't done it, you have to contact events@asil.org.